fraud falls into a broader category of crime of moral turpitude or crime of dishonesty. The one that comes to mind most often is check fraud, where you're passing off a check as fraudulent or you're signing someone else's name. The whole basis behind the law is deterring people from ill-gotten gains, from fraudulent activity, normally having to do with using other people's finances, be it credit cards or checks. So a fraud crime doesn't really define one specific crime, but a whole family of crimes that are prosecuted very aggressively in California, just as aggressively as alcohol-related crimes or violent crimes. Normally the amount of the loss, depending upon what the fraud was, be it how many checks were used, what was the amount of the checks, how many access cards were used, normally the amount of loss or the detriment to the victim is what they're going to use to define misdemeanor or felony, because really these crimes are wobblers. So whether they prosecute as a misdemeanor or a felony is dependent upon the facts and circumstances, and obviously what lawyer you get and whether or not that lawyer can impress upon the DA's office who you are as a person, play up your lack of a prior record, etc. But really these crimes are almost always wobblers, so it can go one way or another in terms of prosecution. First thing I'd want to do is get a statement of case and a social history so I can learn more about who the client is and what the allegations are. If I can show that the client never had an intent to defraud anyone, it's difficult to prove any of these fraud crimes, because normally these are specific intent crimes where you have to intentionally defraud someone, intentionally deprive someone of their property or their possessions. And if I can show that my client didn't have that requisite intent, then oftentimes we can beat the case.